Yes, please.
Madam Chairman and Senators, thank you. As you most likely know, this wasn't an issue until 1997 when the courts and the counties separated their responsibilities. And I just do point out that in the 2003 Probation Task Force report, the item of split authority is an issue. Unfortunately, it didn't give a resolution to that issue, but it is pointed out. As a chairman of the Board of Supervisors, I've had the opportunity to see how it can complicate issues, whether it be in personnel matters, employee contracts, or even budgetary issues, items that potentially can cost the taxpayers of Nevada County additional dollars, that it is a major issue. And more importantly, with, as you know, AB 109 coming on, more responsibilities are going to be added to the county's role in the probation department. So I ask that that's being taken under consideration. And I would like to point out an example of how this gray area can happen here. We met in February with our judges. We went over the situation. My fellow supervisor, Ted Owens, here sat in on this meeting. And when the meeting was over, we felt that both the judges and county management were on the same line as to introducing this bill. And it wasn't just a couple weeks ago we received a copy of a letter to Senator Gaines from the court saying they were opposed to this. And in that 2 weeks' time, because of the busy schedule of the judges, there's no time to sit down and meet and try to work this out further. So it's just a good example of the problems that we have with this. We feel that a permanent solution is needed, especially in light of AB 109, and that to point out other general law county probation department and courts seem to be functioning well under a single governance model. Thank you.
Thank you.
Thank you. Madam Chair and remaining honorable members of the committee, I thank you for sticking with us here. I've been told that brevity is an art, so I will practice it right now. I'm Ted Owens, Nevada County 5th District Supervisor, in support of SB 858. This bill for Nevada County solves the problem of service to two masters, which was identified in the task force report in 2003. And that presents problems that the chairman just pointed out to you. We probably all are familiar of the child that tries to play one parent off of the other parent. I tested that theory as a young child, found it to be not too fruitful for me. But that's the condition that we have. It's not a good business model. It's not a good governance model. I'd like to thank Senator Gaines and, again, reiterate the point that we did sit down with our Superior Court, the presiding judge, the assisting presiding judge, and the CEO with our staff and discuss this matter, at which time they aired no opposition, but were, in fact, in recognition of the difficulty of proper management of the probation department under the two-master system. In our view, probation could be entirely under one umbrella. The court was not interested in putting anything new under their umbrella, and so we proceeded with Senator Gaines to bring forth this bill. This bill would give the authority to appoint to the Board of Supervisors in Nevada County, and we would continue in sharing the liability, the responsibility for counsel and supervision of our employees as with all other employees. And as the chairman pointed out, in view of realignment and its impact on local government, on small counties in particular, it's a whole new world. SB 858 at this particular time will aid in our adaptation and enable us to improve and elevate the level of service that the probation department provides the court. So I strongly suggest your aye vote today. Thank you.
Thank you.
Karen Lang, on behalf of the Nevada County Board of Supervisors, want to acquaint myself with the comments already stated and urge your aye vote. Thank you.
Thank you. Are there others in support? Are there speakers in opposition to the bill? Please come forward.
Thank you, Madam Chair, members. June Clark, representing the Judicial Council. The Judicial Council is opposed to this bill, despite the fact that it is, in its current form, affecting only one county. We see nothing unique about Nevada County. I would respectfully, when it comes to the relationship between probation and the courts, and I would respectfully elaborate on what Senator Gaines had said, where this bill, he would suggest, aligns the county's control of the criminal justice system. I just want to point out that the bill doesn't do anything to change the probation department's function. The function they serve is to carry out the orders of the court, to provide sentencing reports to the court, to enforce the court's terms and conditions of probation. And there has to be that trust and confidence and relationship between the court and the probation department. The Judicial Council doesn't disagree that there is a place for collaboration. In fact, not only does the council support that, it facilitates it and has developed materials that help counties operate collaboratively when it comes to individual chief probation officers. It is my understanding, in fact, that there was collaboration in the context of whatever issues there are with the probation chief in Nevada County. The court is not aware that there's a disagreement between what the board is asking to do and what the court is willing to do. We're not aware that there's any disagreement there. And I would just say that the Nevada County Superior Court, in fact, is strongly opposed and sees this as something that would, in fact, put probation chiefs in an untenable position, while they absolutely understand the need to work within the budget, the fiscal budgetary constraints, collaborate with the Board of Supervisors on the issue of the chief. They are opposed to a statutory change that would give this appointment and removal authority to the board. Thank you.
Thank you.
Karen Pank on behalf of the Chief Probation Officers of California. We too respectfully oppose this bill for many of the reasons just stated, but we'd also point out that sometimes there are good reasons to have a bifurcated governance system, and in this situation, it is true, it's often difficult. Chief Probation Officer does at times serve two masters, but there's reasons for that. The budget control does still go through the board in each of the counties, and so they are accountable to the board for those fiscal type decisions just as any other county department head, and that seems appropriate. We would argue that the role with the chief probation officer in the probation department with the courts, as pointed out by the previous speaker, is very key. It's an important check and balance in our system, and it's important not to over politicize potentially that particular appointment. So the Probation Services Task Force report that was both referenced in the committee analysis as well as earlier here, does talk about that there has been over the years this discussion, and I think it's because of the tension back and forth. But again, sometimes tension does give us a good balance in the system, and for those reasons, we're concerned about the unintended consequences, perhaps, of just trying to resolve an issue that one particular county has as it would relate to the governance of all counties statewide. There are different systems in each county. Obviously, it works best when there's collaboration, and so we would ask for the current state of the law to remain the same.
Okay, thank you very much. Are there other speakers in opposition? Seeing and hearing none. Are there questions or comments from members of the committee? Seeing and hearing, Senator.
Address a very specific problem here. I'm just concerned that we are setting a precedent. I am persuaded by the comments by the Judicial Council, and certainly would like to encourage a continued discussion. I don't know if that's out of the question, coming to some kind of understanding. It looks like this is the approach you're taking because it was a roadblock, because there was no failure in ability to come to some understanding. And I just think it's a different, it's not the best approach to take. I can't support it at this time, but I do appreciate the effort.
The bill has been moved by Senator Harmon. The motion would be do pass. But I will not be able to support the bill today either, Senator Gaines. I think it's a piecemeal construction that really doesn't make sense from a policy perspective, and I'm sorry that Nevada County's had a difficult time coming to terms with this. But you could become a charter county, which are the only other counties, some of which do this. But I do want to make sure, if you would like to close and address any of the concerns,
Yeah, I
please do.
would.
The motion has been made.
I talked about, there was some testimony about check and balance, and there is no check and balance, other than the county is writing the check. But there's no accountability, and you've got an issue here that I think is going to be more and more critical as you move forward with AB 109 and realignment in terms of who is responsible. And there is no aspect of accountability here. I don't understand why the judges would tell the county supervisor they didn't have an issue with this and then suddenly publish a letter in opposition. But clearly someone influenced that decision and they changed their mind. So I think there's more to it than what you're seeing here in the committee hearing. And it seems to me that if you're paying an individual salary, you ought to be able to have some accountability put in place in terms of making sure that that individual is following through and doing performing their duties. And that maybe what you ought to do is realign through the courts so the county doesn't have to deal with this. It should be one way or the other in my mind in terms of the lines of responsibility. Because I think what you've done is set yourself up for natural conflict between counties and courts throughout the state. So I would urge your I vote. Thank you.
Thank you. It's been moved. Do pass. The secretary, please open the roll.
Okay. Hancock?
No.
Hancock, no. Anderson? Calderon? Harmon? Aye. Harmon, aye. Liu? Price? No. Price, no. Steinberg?
Okay. Your bill is on call. Senator Gaines. Senator Alquist is here for item number 5, SB 139.
Thank you, Madam Chair. I'd like to start by saying I appreciate the work the Chair is doing with respect to reorganizing the Office of the Inspector General and would like to take the amendment offered on page 9, comment 4.
Thank you.
SB 139 requires the Department of Corrections and Rehabilitation to conduct random searches of all employees and vendors entering a prison to detect contraband. The bill would allow the Office of the Inspector General or its successor to oversee at least one of the department's searches per year per institution. Additionally, the bill requires a report to be generated detailing what was found in these searches. Contraband, as you know, is a major problem. The number of cell phones confiscated in prison in 2006 was 261. Last year, that number jumped to 10,761, which was an increase of 4,023%. Prisoners are paying up to $1,500 to have cell phones smuggled in. Cell phones are being used to orchestrate crimes, harass witnesses, organize retaliation against other inmates, and even order hits. I think this bill is really necessary, and I have witnesses to speak in support.
We're a little concerned because we have to leave this room in 15 minutes. That's why staff was speaking with me. But so if people could keep their remarks focused and concise, I would appreciate it. Speakers in support.
Thank you. My name is Denise Nelson, Alliance Support Alliance. We advocate for increasing grants and parole to prisoners. Thank you. We are the people that visit the prisons every weekend. Our access to the prisons and our conduct when we are there is very tightly controlled. We are subject to intense scrutiny, search, and pass-through metal detectors at every visit, yet the innuendo remains that we are the primary conduit for contraband, including cell phones, into the prisons. We know this not to be the case, and we believe this bill gives the Department of Corrections an important tool to address the major conduit into the prisons of cell phones, and that is through staff. In the interest of safety and security, we have an abiding interest in safety and security in the institutions, and we think this is an important way to address it. We really cannot see any reason that any stakeholder, be they organization or individual, could oppose this common sense approach to security, and we ask for your aye vote.
Thank you.
Marty Veronica on behalf of the California District Attorneys Association. We're in support of this measure. Thank you.
Thank you.
Jim Lindberg on behalf of the Friends Committee on Legislation of California. We think that everybody coming and going through prisons should be subjected to some sort of security screening, not just visitors. And without a means of detection, we think that penalties don't mean a whole lot. We're in support. Thank you.
Thank you. Others in support?
Good afternoon, Madam Chair, members of the committee. Bruce Monfrost, Acting Inspector General, Office of the Inspector General. I'm just going to echo my previous comments with respect to the Office of the Inspector General's ability to perform these monitoring functions. It's going to be tied very closely to our discussions concerning Senate Bill 490.
Thank you. Any other speakers in support? Are there speakers in opposition? Seeing and hearing none. Are there questions and comments from the committee or Senator? The bill has been moved by Senator Price. Do pass as amended to appropriations. Senator Alquist, if you'd like to close.
Ask for your support.
Thank you. Secretary, please open the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Calderon. Harmon. Aye. Harmon, aye. Liu. Price. Aye. Price, aye. Steinberg.
That bill is on call, and thank you very much.
Thank you very much.
It is a common sense bill. Move this forward. Would the desk please call Senator Padilla, who still has to present a bill, and Senator Price, I think you're up. Yes.
Senator Padilla is still in energy. He's going to try to get here. If not, he'll have his staff present.
Okay. Okay, Senator Price. This is item 18, SB 756.
That's correct. Thank you, Madam Chair, Senators. Thanks for the opportunity to present 756 this afternoon. Let me begin by indicating that we'll be making the author's amendments to page 4, line 4 of the bill that makes which will state that required presentation of proof of residence is to be limited to when law enforcement is actually at place of residence, as recommended by staff. That being said, 756 is sponsored by Attorney General Kamala Harris and is a simple clarification of the jurisdiction authority of law enforcement agencies with respect to sex offenders who undermine registration requirements. This category of offenders, known as absconders, those who do not register at their place of residence or do not live where they are registered. Senate Bill 756 is a positive step towards ensuring law enforcement is advantaged in protecting our society. We're joined today by Janet Neely of the Attorney General's Office. She also serves on the Sex Offender Management Board and the Sex Offender Risk Assessment Committee, and we appreciate her testimony this morning.
Thank you.
Good afternoon. Janet Neely from the Attorney General's Office. Be happy to answer any of your questions about this bill.
Thank you. I think the bill is fairly straightforward. Is there witnesses in opposition to the bill?
Madam Chairwoman, members, Francisco Labaco on behalf of the ACLU. We are not officially in opposition to the legislation. I appreciate the changes you made to that provision that the Senator referenced. I only want to raise that we'll continue to speak with the AG and staff. I do have some concerns about the requirement that you come to a place you're supposed to provide evidence of your potential violation. That may, in fact, raise some Fifth Amendment issues, but we'll continue to speak to the author and try to work it out. Thank you.
Thank you. Are there questions and comments from members of the committee? The bill's been moved. Would you like to close, Senator Price?
Appreciate your aye vote. Thank you.
Thank you. Madam Secretary, the bill is due pass as amended to appropriations.
Hancock.
Aye.
Hancock, aye. Anderson. Calderon. Harmon. Aye. Harmon, aye. Liu. Price.
Aye.
Price, aye. Steinberg.
That bill is on call. I think that I have the last bill. And then, we do have the consent calendar, so it would be good if sergeants could call the absent members. Oh, Senator Harmon, would you like to
Oh,
share?
I can get by without it, I think, but pass it down. All right. This is file item number 11, SB 490 by Senator Hancock. Please proceed, Senator.
Thank you. Thank you very much, Mr. Chairman and member of the committee, members. I want to start by offering an author's amendment to include medical inspection to the mandatory duties of the new office.
All right, fine. We'll take those as author's amendments.
Thank you. SB 490 would do two things: streamline the Office of the Inspector General to focus on its core functions, and it eliminates unnecessary peace officer status in the OIG. It would save the state between $5 and $12 million in general funds. It also renames the Office of the Inspector General to a more accurate description: Office of Independent Correctional Oversight, which was the reason for originally setting up the OIG's office, and replaces the Inspector General with the director appointed by the governor, subject to Senate confirmation. The bill focuses the agency on its 4 core duties as watchdog of California's prisons. The office would continue the very important current duties of the Bureau of Independent Review, which does real-time joint investigations of internal complaints in our prison system, would continue the medical inspection program, the vetting process for wardens, and also the activities of the California Rehabilitation Oversight Board. In addition, the bill would eliminate the unnecessary use of peace officer status in the office. A recent report by the Senate Office of Oversight and Outcomes found that attorneys and auditors in the OIG receive peace officer status, which means essentially a gun, a car, and 3% retirement at age 50, despite the fact that their job duties do not require the specialized functions of frontline law enforcement officers. Members, during this fiscal crisis, when we have cut funding for many, many direct services and many valued and needed services for our people of California, possibly we'll need to cut an additional $12 billion. We cannot afford this kind of redundancy in state government. SB 490 is about being good managers of public money and reforming pensions, reforming and being careful about the use of police officer status, and will ultimately be good public policy and save the state money. I would ask for your aye vote. And
all right, thank you very much. I think we have witnesses in support, so let's ask witnesses in support to please give their name and testimony.
Mr. Chairman and members, Paul Curry on behalf of the Correctional Supervisors Organization. We're in strong support and deference to the time. We won't go into a lot of detail. If there's any questions, we're ready to answer.
Next witness.
Good morning, Mr. Chair.
Have to press the little red button there, sir.
My apologies. Good afternoon, Mr. Chair, members of the committee. Bruce Monfrost, Acting Inspector General, Office of the Inspector General. We do have several concerns regarding the bill, including what constitutes an oversight review, which the bill contemplates the office will be conducting. That said, based on recent conversations we've had with the author's office, I am optimistic that we will be able to resolve those concerns in such a manner that enables the office to continue to perform effective oversight of the CDCR while doing so in as cost-efficient and effective manner as we can, and we look forward to working with the author's office in
All
these
right.
matters.
Thank you very much. Are there other witnesses in support? Seeing none, are there any witnesses in opposition? Seeing none, are there questions or comments from the committee members? Senator Liu? Senator Liu moved the bill. Secretary, please call the roll.
Whoa, that was good.
Oh, I did ask for a vote, didn't I? Oh, close, yes.
I would
thank
ask
you.
for your aye vote.
Yeah, all right, we've got it. Close. Now the secretary called roll.
Okay, it's do pass as amended to appropriations. Hancock.
Aye.
Hancock, aye. Anderson. Calderon. Harmon.
Aye.
Harmon, aye. Liu. Liu, aye. Price. Price, aye. Steinberg.
That bill is on call.
That bill is on call. Now, what about the consent calendar? We have just one bill on the consent calendar. Is there a motion that would be on Senator Strickland's bill, file item number 8, SB 428, the consent calendar? Members, is there a motion?
We should recess now.
Moved by Senator Liu. Clerk, call the consent calendar.
Hancock.
Aye.
Aye. Hancock, aye. Anderson. Calderon. Harmon.
Aye.
Harmon, aye. Liu. Liu, aye. Price. Price, aye. Steinberg.
Okay, the committee will now recess. We will, for 10 minutes, getting closer to it as I've been telling witnesses. We have to vacate this room now for another committee. We're going to move downstairs to room 2040. We'll reconvene in 10 minutes. We have to do one bill, and then we will have the roll open for absent members. So thank you all. The committee is in recess.